welcome to our Founders Friday session today on employment law basics for the end of March 2021. My name's Catherine Hope. I'm an associate solicitor in the employment team at Sintons. I thought I would cover some sessions today on some of the employment law basics. I think it's really important for you to look at if you are an individual or an organisation and you're taking that next step where you'll be looking to engage staff for the first time as your business expands. And we'll be looking at the different types of relationship and just some of the really important things you need to think about and be aware of if you're taking that step. So today we're going to look at employment status. So we'll be looking at employees, workers, self-employed, employment contracts and the requirements there from a statutory perspective, the law on unfair dismissal, discrimination under the Equality Act, and finally looking at disciplinary and grievance procedures and also the statutory ACAS code on those as well. So that's just an overview of the things we'll be covering. And it's just important to, I'd say, keep this as a record of things to look back on and make sure you're aware of when you're employing individuals or engaging them for the first time. So starting with employment status, in the employment realm, there are three different types of status. We have employees, workers, and the self-employed. And it's really important when you're looking at engaging staff for the first time, thinking about and being clear as to what relationship you're engaging them on. And it's important because that has implications in terms of the rights and your obligations in relation to them. In terms of an overview, employees have all of the entitlements in terms of going right up to the rights in terms of unfair dismissal, statutory rights such as maternity leave, paternity leave, shared parental leave. Workers, which are the hybrid really between employees and the self-employed, do have access to some of those rights, the main ones being holiday pay, national minimum wage, statutory sick pay. And then when you come to those as self-employed, they don't have any of that protection. The only protection they do have is really in relation to discrimination under the Equality Act. So it's really important to be aware of those. Starting with employees. So employees, there's three really distinct factors that you need to be in place here when you're looking at an employment relationship. And they're referred to as the irreducible minimum. And when I've set those out on the slide, but we're looking at personal service, control and mutuality of obligation. Personal service, so there is the obligation for the individual themselves to come and provide the service. So for example, I can't send a friend or a family member to come and do my job at Sintons. I can't provide a substitute. I have to provide that and I'm contractually obliged to do that myself and come up and turn up and do that work. Control. There needs to be that element of control, whether that be in terms of the hours of work someone is expected to do, when they're expected to work, where, and the manner. There needs to be that, you'd be looking at kind of policies, procedures, the way in which you do things. There isn't that freedom that someone who is self-employed would be expected to have. Obviously, that will differ between different roles and different levels of seniority in terms of compared to junior positions, but there does need to still be that element of control in that employment relationship. Finally, and probably the most important one, is that mutuality of obligation. What I mean by that is there's the obligation on you as the employer to provide a certain amount of work, whether that be a certain amount of hours, 9 to 5, and access to that work and payment for it. And then on the flip side, the obligation on the individual to turn up and do it. There's the contractual obligation, and if you don't turn up, there is obviously ramifications and you could be subject to disciplinary procedure. So that's the basics of an employment relationship. We then come to this hybrid in terms of a worker, and there is a statutory definition for worker under the Employment Rights Act. Employment Rights Act is a really important piece of legislation which you will really come across quite often if you are becoming an employer for the first time. So do be aware of that, and it's just a good reference point in terms of a lot of the rights and obligations that apply to the employment relationship. Now, worker status, again, there are two factors here. You need personal service. So again, you don't have the ability to provide a substitute in your place. You have to provide that service, that work personally. Secondly, there has to be a contract in place, which includes employment contracts. So employees are automatically workers as well. But it's a contract where there is a provision of work, but where the important factor here is that the person that work is being carried out for is not a client or customer, which is the case in a self-employed relationship where you are providing a service to a client or a customer. Here it's different, and with workers it's recognizing it's not a clear employment relationship, but there still is that element of control where someone is working for someone else. It's not that equal bargaining position that you would have with a self-employed relationship. What you'd be looking at, I guess a clear example of this would be if you've got casual workers, so you've got a bank of casual workers, staff that you can call upon, and you as the business might contact them and say, I've got these hours to work, who can do them, who wants to take them? So you're not obliged to provide any amount of work or work on a certain day. You know, you don't have to provide 9 to 5 hours every week and pay someone for that. And on the flip side, the individual can turn around and say, no, thanks, I'm busy that day, I'm doing someone else. So they don't have to accept that work. So it's that flexibility, that's the difference. There's not that mutuality of obligation. Obviously, when they do accept that work, they are obliged to turn up and do it. But that's the difference. You'd also be looking at, I guess, a worker is also someone who's probably going to be seen to be integrated and seen as part of the organisation from an outsider's perspective. And that's one of the other differences between workers and self-employed. Again, as I mentioned, it's important really to be aware and decide whether someone is either a worker or self-employed, because there is a clear distinction in terms of rights there. Important ones being holiday pay. And you could end up in a situation where there's a significant amount of liability if you've not been giving someone paid holiday, giving them that right when they are in fact a worker. You'll probably have heard in the press in the recent weeks the Uber case, where there are a number of drivers who were providing private hire services, and they were claiming they were workers and they were found to be. And it's just an important note on, you can have contracts in place where the way in which they're drafted suggests that someone is self-employed, but actually when you look behind that and look at the reality of the situation, if there's a certain amount of control, there's not that freedom you would expect for a self-employed relationship, then it's likely, there's a real risk there that there will be worker status and the liability that comes with that. On a final note, self-employed status. So really, if someone is genuinely self-employed, you would expect they're a business on their own account. That will be, you as startups, when you're starting up, you're setting up your own business. You are then providing those services to the world at large for whoever needs those. You have that freedom to work when and how you want. You should expect there to be a contract, whether that be a project you're fulfilling or providing certain services. You would expect to work for various clients, not just working, every day and every week for the same client. You can also expect that you could look to employ your own staff or engage your own freelancers, contract workers to provide work and assist you as and when you need it with particular skills or extra hands. You'd also expect someone to carry that financial risk with self-employed status, where the benefits are you can profit from your situation. Say you've got a project to fulfill and you put all of your work into it and complete it very quickly. You've got the benefit of that because you've got your fee, but you've freed up your time to then start other work. On the flip side, you have the risk where if something goes wrong, you would be expected to remedy that, but without fee. Whereas obviously if someone is employed and a mistake is made, they are still turning up to work and being paid for that time. So it's that balance. And of course, from a tax perspective, you would be dealing with your own tax and national insurance rather than going through the payroll, as will be the case for workers and employees. So just important things, it's really important to be aware and decide on how you're engaging someone before you take that step, having that contract in place. Talking about contracts, if you are engaging someone who is an employee or a worker now, there was a change that came into play last year where workers are now covered by Section 1 of the Employment Rights Act. Section 1 covers the minimum terms that you have to have in place in writing when you're engaging an employee and now workers. It used to be the case that you would have to put those in place within 2 months of someone starting, but the law changed last year and it's now on or before the day one. So it's really important to be aware of what you need to have in place. There are certain particulars you need to set down in writing and give to an employee and a worker, and they'll include things such as who their employer is, the hours of work they're required to do, if they will vary, if so, how that variation will be determined, their holiday entitlement, pension information, sick pay entitlement. There are a number of things, and it's important to be aware of some changes that came into play last year, just in case you've picked up some information and that's changed. Last year, there were some changes that came in whereby certain information has to be given about benefit entitlements, or if there aren't any benefit entitlements, confirming that's the case. Information on training and the access to that, certainly mandatory training, and also entitlement to other paid leave. So if you are engaging someone as a worker or employed, do bear that in mind and make sure you've got the contracts in place ready for them starting. It's not that someone would immediately have a claim if you fail to do that, but if they do have another substantive claim, such as unfair dismissal, which I'll come on to, they can tag on a claim for failure to provide the particulars under section 1 to that. And I believe they can claim up to 2 weeks' salary. So it's an important thing to be aware of. And also from a business perspective, it's not just about having things in place that you have to. It's going to be really important for you to have a contract in place to protect you commercially. There's some beneficial terms that you can put in place for you as a business. And it just means you're both clear, you and the person you're engaging, as to what the contractual terms are. Unfair dismissal, again, this is a really important thing to be aware of if you are employing staff. This really comes into play once someone has 2 years service. So generally, once someone has 2 years service with you, they have the right not to be unfairly dismissed. And under the Employment Rights Act, section 98, it means that if you're in a situation where you want to terminate their employment, whether that be for their conduct, something they've done, their attitude, or their performance, they're not performing to the standard that you require, you would have to have a potentially fair reason to terminate their contract. And secondly, you would have to have shown that you've acted reasonably in treating the reason for their dismissal as sufficient to justify that. Potentially fair reasons, there are a number of ones set out in the Employment Rights Act. There are 5 of those, including conduct. So if there's been an issue with misconduct, alleged misconduct, capability, whether that be performance issue or ill health, if someone is no longer capable to carry out their job because of ill health, redundancy, and there are a few others there, including some of the substantial reason, which is a catch-all where something may not necessarily comfortably fit into one of the other categories. So you need your fair reason, you then need to have acted reasonably. And when we're looking at that, we're looking at procedural fairness and substantive fairness. So procedural fairness, you need to have followed a fair procedure before you get to the point where you actually terminate. This is going to differ depending on the reason. So if you think about disciplinary, if there's a conduct issue, you'd be expected to carry out a thorough investigation, decide whether disciplinary action is necessary, invite someone to a disciplinary hearing, clearly setting out the case against them, giving them that chance to defend themselves, put their case across, then making a decision as to the sanction. If that is dismissal, then giving them the right to appeal. You then need to be clear that if you're at that point deciding to dismiss, is that fair to dismiss as opposed to giving someone a final warning or a warning? And that will depend on a number of factors: A, the seriousness of the misconduct, someone's length of service, their disciplinary record, so a number of things to consider. Separate to that, differently, would be a redundancy situation where you would be expected to go through a redundancy consultation process where you're consulting with staff about ways to try and avoid compulsory redundancy, looking at other alternative jobs within your business before you ultimately decide their position is redundant. Again, it needs to be at that point at which you dismiss that you are able to show that your decision to dismiss has fallen within a range of reasonable responses. So do bear that in mind if you are looking to terminate. And there are a number of situations where length of service isn't relevant, but that's, for example, where someone has whistleblowing and you terminate their contract because of that, or they've raised particular health and safety concerns. Now, if someone has an unfair dismissal claim and they are successful, they can claim a basic award, and the award in that respect is similar to a statutory redundancy payment. They can also claim a compensatory award, and that's based on the losses they've suffered resulting from the dismissal. And the amount of that will all be dependent on whether they're able to get new employment and what their salary is like compared to what their salary was with you. So really important to be aware of, because it can amount to significant liability if you get things wrong. Discrimination under the Equality Act. It's really important to be aware of the protected characteristics that are covered by the Equality Act. And there are 9 of those. We've got age, disability, gender reassignment, marriage and civil partnership, pregnancy, maternity, race, religion or belief, sex and sexual orientation. The Equality Act prohibits discrimination on those grounds, and it applies to employees in the employment field. It applies to employees, but also job applicants, so do bear that in mind. And there are a number of different types of discrimination, which I'll just touch upon briefly here. You've got indirect discrimination. So that's where you treat someone less favourably than you would treat someone else because of a protected characteristic. For example, you have someone applying for a job and you don't give them that simply because of the colour of their skin or their sexual orientation. Indirect discrimination, that's where you apply a policy, criterion or practice to everyone, but it ends up putting people with a particular protected characteristic at a disadvantage in comparison to those who don't have that. Classic example of that is if you decide we're not considering any flexible working requests, any requests for part-time working, we can't do that, we just need full-time hours. There's a risk you're going to put more women at a disadvantage there, because it is generally still accepted that more women will take the burden of childcare in a relationship, and although things are changing in that regard, the tribunal will accept that. And if you're in a situation where you're putting that forward as a policy, you're more likely to then put women in a position where they can't apply for jobs, or they can't continue to carry out a full-time role because of their childcare commitments. So you're exposing yourself there to a risk of an indirect sex discrimination claim. Harassment is where you subject someone to unwanted conduct related to a protected characteristic, and that's where that conduct has the purpose or effect of violating someone's dignity or creating an environment that is humiliating, intimidating, degrading and offensive. And that's kind of situation, you know, whereby if certain names are called, there's particular, I mean, that's where there's a fine line between banter in a particular environment, but somewhere else where it will amount to harassment. So do be aware of that, and you can be held liable for the harassment of your employees if they're harassing other fellow colleagues. Finally, victimisation, that's where you would subject to someone to a detriment if they have complained about discrimination, whether that be they've raised a complaint, they've brought a claim in the employment tribunal, or they're supporting someone else in doing that. Finally, it's important to note that in terms of the protected characteristic of disability, there are certain other types of discrimination that can arise. You have the duty to make reasonable adjustments. So if you have an employee who is disabled under the Equality Act, you have a duty to make reasonable adjustments if required to enable and help them to do their job. That might be if someone suffers from fatigue at a particular time of the day that affects their ability to carry out their job. You may look at adjusting their working hours so that when they are most effective and productive and they can actually do their job, whether that be starting at 10, working later, or finishing early. That would be a reasonable adjustment to enable someone to carry out their job if that is causing difficulties. Another one to consider, and really important that you might not be aware of when it comes to disability discrimination, is discrimination arising from disability. The classic example of that is if you have someone who has a number of periods of sickness absence, and that's becoming a difficulty in terms of resource, and you move to dismiss because of their sickness absence. So you're not dismissing them because of their disability, but if their absence is a consequence of their disability, so it's disability related absence, it could give rise to a claim because you're dismissing them because of something arising in consequence of their disability. And in that situation, if you're in a situation where unfortunately someone ends up being incapable of carrying out their role, that's like any capability issue, if it's coming to a point where you're concerned about their ability going forward, you would need to get independent medical professional advice to confirm that. It's a process that you would need to go through and provide that support, look at alternatives. Disciplinary and grievance procedures. It's really important, I'd say as a minimum, that certainly if you're taking on a number of members of staff, that you have disciplinary and grievance procedures in place as a minimum in terms of your policies. If you're looking at disciplinary procedures and or grievance procedures, think about unfair dismissal in the background, especially if someone has 2 years service. You also need to be aware of the ACAS code, and I'll come on to that in the final slide. That's a statutory code of practice which sets out steps to follow when dealing with disciplinary and grievance procedures. But also do be mindful of other things that can crop up in disciplinary and grievance procedures and when you're dealing with those. Discrimination, that could crop up in terms of how you're dealing with those whether you're dealing with a grievance complaint or a disciplinary process. If you're not dealing with things consistently and differences are related to protected characteristics. Also, duty to make reasonable adjustments. That may well be if someone needs extra support when you're having a hearing, whether that be attendance by family members, that support to enable them to fully engage in a meeting, a reasonable adjustment during that process. Do consider that and make sure you're listening to staff if they raise concerns. Breach of contract, if procedures are contractual, it's rare. So make sure when you're putting procedures together that you make them non-contractual, and it means that you can adapt those and amend them as required. So I mentioned the ACAS Code of Practice on Disciplinary and Grievance Procedures. ACAS is a conciliatory service, and they also provide a great deal of resource in terms of training, resources, advice that's really useful and important for employers, certainly when they're starting out. And they have a number of statutory codes, and one of those is the ACAS Code of Practice on Disciplinary and Grievance Procedures. What it means when we say a statutory code of practice is the Employment Tribunal must take it into account when they are looking at fairness in terms of an unfair dismissal claim. And if, for example, someone brought a claim against you for unfair dismissal and they were successful and they were awarded compensation, it is within the tribunal's powers then to uplift their compensation by 25% if you didn't follow the ACAS code. In brief, when we're looking at disciplinary procedures, the ACAS code sets out certain steps you should follow. For example, carrying out a thorough investigation, setting out the case against the employee, inviting them to that meeting, giving them the right to be accompanied, making that decision once you've heard and given them that chance to put forward their case, and then giving them that right to appeal. So make sure that your disciplinary procedures and your grievance procedures as a minimum include the steps contained in the ACAS code. You can find that on the ACAS website. It's very accessible and easy to get to. So do bear that in mind. So it's not that if you fail to follow them, someone will have a claim automatically, but it will become relevant and important if a claim is then brought separately in the Employment Tribunal. So that's just a brief overview of some of the things that I would say do think about and become aware of when you're becoming an employer as a starting point. I hope that's been of use, and I'd like to thank you for joining us today for this session. If you do have any questions that come out of it, please do raise them. You can see my contact details on the Sintons website in the employment section. I'm Catherine Hope, and we have a number of solicitors in the team here. So please do not hesitate to get in touch. Thank you very much.